Sure. How you doing today? Oh man, we're trying to get this Kelsey Fitzsimmons court hearing up, and I'm hearing it may have already happened, but I'm not sure. What we're still standing by. There was a medical emergency in the courtroom. We're still trying to get the feed up. I don't know what's going on, but I do have some new news on Kelsey Fitzsimmons today to go over. So I figured we'd just take a look at it right now. Let's see if I can bring it up. Can I bring it up? Let's hold on. Let's do this. Hold on. Hold on one moment. I've been outside. Let me oh I know it is cold out there. It's supposed to warm up today, but it is still cold. Let's bring this up. We have a new some new documents about the recusal. We blow that up on the screen. Hold on. Let me you know what, I'm gonna do this instead. I like this better. Hold on. Hold on one moment. Wait one moment. I just want to make sure I have it up. I want it blow up for me. Ah, damn. Hold on one moment. I know what I need to do. Let's just bring it up this way. Okay, we got it. Oh, let's remove this. How do we do this? Let me just check in on the courts too, make sure that the hearing hasn't started streaming for some reason. I'm hearing it may have already happened. I don't know what's going on with the streaming, why there's no streams today. All right, so we do have a new motion. How do I get this off? Hold on. All right. All right. This is a a new motion that's been filed by the defendant, Kelsey Fitzsimmons. And the defendant's motion is to recuse Judge Kathleen McCarthy-Neyman and to request for an evidentiary hearing. We've got the exhibits, we've got the new filing. I figured we'd go over this and we'll check in and see if there's any type of stream that is available. Doesn't look like it's going to be available today, unfortunately. Damn it! I wanted to watch that today. I should probably run over to court right now, but I've been just trying to stream this all day, so there's no way I can get over there in time. And they may have rescheduled the hearing. Yeah, they moved it. They moved the hearing today because somebody collapsed in the courtroom. But let's go over this. This is the new filing. Defendant's motion to recuse Judge Kathleen McCarthy-Neyman. They want the judge off this case. Let's read this. Now comes the defendant, Kelsey Fitzsimmons, by and through counsel, and hereby files the instant motion to recuse Judge Kathleen McCarthy-Neyman. As grounds, it is apparent that a reasonable, disinterested observer being appraised of the facts of the judge's involvement in the case would conclude that there is a lack of impartiality, or at a bare minimum, an appearance that the judge's impartiality might reasonably be questioned. The instant motion is made pursuant to the Due Process Clause of the 14th Amendment of the United States Constitution, Article 29 of the Mass Constitution Declaration of Rights, the provisions of the Supreme Judicial Court's Code of Judicial Conduct. So you can already see it here. If this judge turns this down, which I expect, they're already citing SJC, Code of Judicial Conduct. That's a hint that this probably is going to go to SJC if this judge turns this down. But they filed this today, and they're requesting an evidentiary hearing for it. I'm not going to read all of this out loud, but I'm putting it on the screen. You can read it. I'm just seeing if there's anything good. This just came out. This is brand new. Nobody else has this yet, or if they do, they haven't gone over it yet. We're going over it right now on the fly. And they're just basically citing law about it. And I'm just seeing if they post, if it's include. This is all the different laws that they're citing. Let's see if they cite anything about what she did. Here it is. A judge is disqualified from any matter if the judge cannot satisfy both the subjective and the objective standard. The subjective standard requires disqualification if the judge concludes that he or she cannot be impartial. This is looks like 15 pages of this. They're citing all the different laws. All right, this is what I want. The procedural background relative to recusal. Miss Fitzsimmons is before the Essex Superior Court, sitting at Salem in a one-count prosecution charging assault by means of a dangerous weapon. Judge McCarthy-Neyman presided on the case on August 14th, 2025. We all saw this, for a bail petition at Essex Superior Court on August 28th for arraignment, September 9th for a bail hearing, and September 11th for an emergency motion for immediate relief from Scram. On both August 14th and August 28th of 2025, Judge McCarthy-Neyman was assigned to Salem's Civil A, Courtroom H, handling civil business in the Salem Superior Court. See Judicial Assignments sheet. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in court or on the docket. That's very suspicious. She was supposed to do civil, and all of a sudden she's assigned the criminal, and they don't tell them why. So they have some exhibits. I'm going to show those in a minute, too. Nonetheless, she continued to leave the civil session and handle criminal business in Miss Fitzsimmons' case. Still without explanation, without notice to the parties or the public, it appears she has specifically assigned herself to this case. A one-count, simple 2 or 3 day trial where a conviction warrants only a sentencing guideline sentence of straight probation. The assignment seems inexplicable on the merits of the case and raises questions about the motive of the court so as to undermine the public's confidence and the ongoing adjudication, whatever that. I have a hard time saying that word. Is everyone with me right now? Can you all see this? Can you hear me? I haven't checked in with the chat. How's the chat doing? Who do we have here? It looks like we got a good amount of people. Good. Yeah, that's what Canoni did, right? Yeah, it's a only criminal case. Good point, Nina. That's what they're basically saying. She was supposed to be assigned civil, and here she is in a criminal case. Ah, this is wild. This is wild. Huh. It looks like we got some good numbers here. I'm happy to see. I'm happy to see y'all watching on YouTube and on Facebook too. We got a lot of new Facebook people. It's funny. Someone came at me about the numbers on YouTube just this morning. They don't care about actual what our coverage is. They don't care about all the cases of corruption that we expose. They care about our numbers. I'm happy to report our numbers are through the roof on Facebook. We had 1.5 million views of our content just this weekend, just yesterday, actually, on Sunday, Super Bowl Sunday, on Facebook alone. Unbelievable, actually. So I hope they're all very excited about our numbers going back up, because we're covering content. Can you read a bit slower? I'm sorry if I'm reading too fast, but there's a lot to get to, and I'm freezing down here. Actually, I'm in my studio, and it is so cold down here. I need to turn the space heater on. I wasn't expecting to go live, but this came out, and the court hearing didn't, so I figured I'd jump on real quickly, and I'll try to get through this as quickly as I can because I do have to go walk dogs. So I'll try to read slower. I want to thank Victory, Vic, I call her. She's always here, great moderator here for us. Thank you for being here. Yes, we all do have a choice. Our content is good. We're getting back to business over here. Yes, and that's the thing. We do offer completely different content. Mostly non-drama experts. That's what we've always focused on. Interviews. There was some few months of drama. People like that. The numbers went up when we did the drama, but I've chosen not to do drama. Clicks and views aren't that important for me. What's more important to me is my life, my lifestyle, and I'd rather have less followers and have them be the real ones that want to get to the serious business of exposing the corruption and the malfeasance and all that stuff without have to create drama between YouTubers. There's a lot of people who crow about their numbers, but all their content is drama, shitting on people on YouTube. That's the way they want to live. That's good for them. Congrats. I'm glad they got their money, but don't compare it to what we do. We're doing serious stuff over here. All right, let's read more of this. Prejudgment reflected in a dangerousness finding and other pretrial matters. This is the grounds for recusal. In upholding prior dangerousness here findings and herself finding Miss Fitzsimmons dangerous under 58A, the judge has been privy to and has adopted as facts evidence that would not come into trial of the underlying charge. That's a good point. This judge, without even a hearing on it, has already. We saw it live in action. She had just assumed everything that had been alleged was true without even a hearing. That's what I saw. And that's what they're putting in writing here. The judge has been privy to and has adopted as fact evidence that would not come into a trial of the underlying charge. The court has made a subjective personal finding that Miss Simmons is a dangerous person. She has repeatedly referenced her belief necessarily by clear and convincing evidence that Miss Fitzsimmons is an ongoing and present danger to her assailant, Officer Noonan, who needs the protection of a dangerous finding from her. That's what's so weird about this, too. I've noted this. This judge, I don't know what her connection is to Officer Noonan, but that would, if I was the judge on this case, that would be the last person I'd be worried about. We've seen the video of how big Officer Noonan is compared to Fitzsimmons. Fitzsimmons has said nothing about Noonan since this incident. She's done nothing to demonstrate that she's a danger to him. If she's really worried about the dangerousness, I'd be more worried about the fiance or the baby, if you really think Kelsey's dangerous, which I do not think so. But she prejudged her. And she prejudged it on Officer Noonan. It's like, is she connected to Officer Noonan? That's what I thought right away. All right, let's get back to reading this. The court has also gone so far as to explicitly prevent any potentially favorable family court custody or visitation orders by prohibiting Miss Fitzsimmons from seeing her infant child, regardless of any custody determinations in that court. So again, she's preventing Miss Fitzsimmons from seeing the baby. And we just had Judge Carol Erskine on the show, a retired family court judge who is like the preeminent child protector in Massachusetts. She thinks it's funny. She thinks it's very strange that they're not letting her see her child, even with some oversight. You know, you can easily have someone from the court or Protective Services or the Department of Family. You could have somebody there. DCF, there could be somebody there to make sure that the child is protected. It could be, and they're not even letting her see the baby at all. Let's read more of this. This is a highly unusual finding, unprecedented. An undersigned counsel's experience that a superior court judge would impair the family court in performing its own court function of determining custody and visitation in the first instance. This court has gone far out of its lane in an effort to keep Fitzsimmons from her infant. The court's findings in these areas amount to an expression of her opinion on the character and guilt of the defendant. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as a trial judge. And parento supram, the trial court's findings that the defendant was untruthful in the past and its failure to recuse at the jury trial was found to be abuse of discretion by the appeals court. Are you reading this? This is unbelievable. You know what? I will try to post this. I'm going to post this in our Facebook groups. I'll post it up in our Facebook groups later, PDF form. The Young Jerks, and also over at our police. We have a police accountability group in Massachusetts, so we'll post it up there as well. I'm sure it'll be posted in the Kelsey Fitzsimmons group as well on Facebook, the PDF. But I'm going to continue to read this right now. All right, so basically they're talking about another case where a judge, should be disqualified for similar reasons. Here, we'll go on to read that. Further, a judge cannot partially recuse himself. Once a judge concludes that there are grounds for recusal, he must completely disassociate himself from participating in the case. So they're basically quoting from other court proceedings, similar court proceedings. Glenn Massou says, send this to me. I'm going to post it up in our group. Check the Young Jerks Facebook group later today. Thank you, Glenn Massou. Yeah, it is disgraceful that they're withholding the baby. The grandparents can't even see the baby, as far as I know, unless something's changed. This is wild. So right now that they are asking this court to recuse the judge. Let's read this part. Obviously, during the course of a jury trial, a judge, by exercising his discretion on various matters, makes important decisions which may affect the verdicts returned by the jury. Therefore, a courtroom has no place for a judge whose impartiality in a matter may be reasonably questioned, even if he is not the fact finder. We vacate the judgments and remand the case to the housing court for a new trial. So they're quoting SJC. They're quoting other precedents in Massachusetts. Let's read the part about Miss Fitzsimmons now. The foregoing findings against Miss Fitzsimmons are equally dispositive for recusal and are further supported by the present court's comments against counsel. I know she made some real ridiculous statements against Tim Bradel already, too. Here in its order dated September 16, 2025, document number 19, this court has alleged the defense counsel did not transparently provide information resulting in a manipulation of the court relative to defendant's physical condition. The defense denies the claim and has not had any opportunity to address it. In any event, the court's personal conclusion in this regard gives the appearance as well as the actuality of partiality on the part of the court requiring recusal, as was the case in Parento. Any other result would be abuse of discretion. Comment 3 to Rule 2.6 of the Code of Judicial Conduct also addresses similar circumstances where a judge is exposed to settlement or plea discussions. So they're quoting the court rules. This is all backed up. This all looks good. This looks like a strong motion. I'm not going to go through all the past court rulings. I'm just going to skip it over. I'm trying to just get to the stuff that really pertains to what the situation with Kelsey is. There it is. The court's prior findings relative to the character and fitness of the defendant as a mother, as well as the court's criticism of defense counsel, conclusively demonstrate that the court's objectivity is tainted, warranting recusal. You know what I'm going to do right now is I'm going to put some shoes on because it's freezing. I'm in my stocking feet, and my feet are freezing down here, and I don't have anything to drink, so I'm going to grab a glass of water here, and I'll come right back. So I'll be back in one moment. I'm just going to leave that on the screen. Do not leave. Please do not leave. I'll be right back. I'm back. I don't know why it muted me. I'm sorry about that. Having a lot of issues with StreamYard. It mutes me randomly now. Can you hear me all? Yeah. I have my space heater on too. I don't know if you can hear it in the background. If it gets too loud, just let me know. Let me take a drink of water. All right, there you go. You have the court. You have the court on record. You have the defense on record calling out this judge for her criticism of Tim Bradle, the defense counsel, which she did do. And she also, her lack of objectivity. They're asking for a recusal. I think this is a good motion. This sounds like a very strong, good motion. Let's read more. Finally, the court's demeanor and actions at the September 11th pretrial hearing also provide ample grounds for recusal. And again, they're quoting Rule 2.3 of the Code of Judicial Conduct, Comment 1. And it basically, look at this. This is what it says. A judge who manifests bias or prejudice or engages in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. The judge must avoid words or conduct that may reasonably be perceived as manifesting bias or prejudice or engaging in harassment. I think this is a strong motion. I don't know if it's going to go through because these courts never seem to ever want to rule against their judges. But, geez, the recording of the hearing accurately preserves and demonstrates the court's prejudice, demeanor, and actions, and should be grounds enough for the court to step off the case on appearance grounds. The defense would admit a copy of the recording at the recusal hearing. We've all heard that. We've all heard that recording. We'll actually play it again today on the show so people can remember what happened. When was that date? Do we have the date here? We'll play that. We're going to play that to end the show. All right, again, it's quoting law in the past. I'm going to skip over this. Here we go. This is the stuff I want to get to. Judge McCarthy-Neyman should recuse herself from the trial and any further substantive pretrial proceedings. Findings of dangerousness and parental unfitness when viewed in conjunction with ex parte communications. See, this is what we don't know. Like, what I'm wondering if this is something we haven't seen yet. What are the ex parte communications? We've seen the personal accusations against counsel. We did see that. And the judge's own extradition. Whoa, what's this all about? What are the. Ooh, look at this. Tim Bradle and Martha Coakley calling out the judge for her own extrajudicial interests. What are her interests? What are her interests outside justice? This is interesting. Did they find out something? What do you think? This is her own extrajudicial interest. What? This is a bomb. What do they know? I know, right? Ex parte. I know. What do they know? They know something that we don't know. I know. Would she eat lunch with the prosecutor? Is she friends with Noonan? That's what I think. I'm like, she's from North Andover. You know, she practiced law in North Andover. Is she friends with the police chief, Ray? Yeah, she is taking this personally. You really wonder, right? They know something. That's what it seems like here. It seems like they know something that we don't know. Yes, the next court hearing is 3/9. I guess today got delayed because of a medical emergency. Someone collapsed in the courtroom or something. Is this wild? The judge's own extrajudicial interest. What are her extrajudicial interests? Wow. Let's keep reading this. This is getting juicy. Yeah, go get him, Tim. Tim Bradle's throwing it down today. And Martha Coakley. This is wild. This is something we all suspected. They all combine to demonstrate that this court has prejudged critical issues central to the case. Continued participation might cause a reasonable observer to doubt the judge's ability to approach subsequent proceedings impartially. This is what we all think. I mean, we all watched and heard the judge, right? Oh boy, look at this. Look at this headline. Personal economic interest creating an appearance of bias. What? What is going on? All right, here we go. Basic internet search shows that Judge McCarthy has resided in the town of North Andover for approximately 25 years. That's what I discovered right away. Public real estate records indicate she is a listed homeowner in the town. She was the founder and the principal of the law offices Kathleen M. McCarthy, a criminal defense firm in North Andover, Mass., and enlisted in Massachusetts Lawyers Weekly, April 29, 2020, as a former sole practitioner in North Andover from 1997 to 2018. And adjudicating the alleged dangerousness of Miss Fitzsimmons, a fellow North Andover resident, in a North Andover incident, the court inevitably had to consider the safety of herself, her own family, and former colleagues that work or live in the town. As a taxpaying resident, the judge has a vested interest in the financial security of the town and its reputation in the Commonwealth. This is a good point. I mean, I live in a town. I always worry about lawsuits and against my town because it means my taxes are going up. We're one of the towns being sued by the AG. That affects my family here, our property taxes. If there's a big payout, so this is interesting. On the unique facts of the case, One North Andover police officer, Patrick McCarthy-Neyman, shot and almost killed another North Andover police officer, defendant Kelsey Fitzsimmons. The police immediately adopted and believed the story of the shooter officer and never sought to interview Miss Fitzsimmons, who fought for her life for 53 days in Mass General Hospital. The case involves only these two officers as percipient witnesses with no body camera video. Wow, they never interviewed her, huh? The police department automatically believed the shooter but didn't interview the person who got shot. That's interesting. The case involves only these two. The defendant has potential civil claims arising from the conduct of governmental actors in this case. Claims that could foreseeably expose North Andover to substantial financial liability. Municipal tort liability directly implicates municipal finances and taxation, and as a resident property owner, the judge has an economic interest that could be affected by the outcome of this criminal trial. Such an interest is disqualifying where it might cause a reasonable observer to question impartiality. I think that's spot on. Oh, I love this part too. Discovery documents provided by the Commonwealth relative to Noonan's trading list his full name as Patrick McCarthy Neyman. It is unknown and undisclosed by the court whether there is a family relationship. Is that strange? What, two McCarthys in North Andover? Another Essex Superior Court judge, Kristen Buxton, recused herself in a similar circumstance as a taxpayer in the town of Ipswich in the matter of Cappy Thorne et al. Versus town manager of Ipswich. So look, Judge Buxton recused herself for the same reason. Judge McCarthy-Neyman should mirror Judge Buxton's decision in Cappy Thorne and withdraw to avoid the appearance of a lack of impartiality. All right. I'm checking in with the chat. I'm checking in with the studio to make sure that StreamYard didn't boot my audio again. All right, we're good. Whew. Yeah, this is getting juicy, isn't it? This is getting juicy. Yeah, his middle name is McCarthy. Can you believe that? We were all looking. I mean, when we saw that Judge Kathleen McCarthy-Neyman acted like that, we all started looking into it. I haven't been able to find it that they're relatives, but it's very strange. I know you all caught up, Justin. Are you happy with the shit you started? Erica says, heartbreaking for Kelsey. This judge should just do it. Like, she shouldn't even require them to go to SJC. She should just recuse herself at this point. All right, I'm going to read some more of this. What page are we on? We're on page 11 out of 15. There's some exhibits we're going to look at, too, with a separate PDF. But let's continue this. Let's get through this. Ex parte, you know what? I just want to check in on court to make sure there's no updates, no video from court today that came out. I'm just taking a look real quick here. Yeah, nothing. Wait. They did update. Hold on one second. All right, the latest update on court today. Her trial had originally been scheduled to begin Monday, but it was pushed back to the end of March 23rd due to conflict with the state prosecutor. Let me see if there's anything else new here. Yeah, it looks like we had no updates from court today. Nothing happened today. But this is what we're going over. This is the big news today. Let's look at this ex parte communications with probation, because this is interesting. This is what they're talking about, number 3. Ex parte communications with probation concerning a pending matter. undersigned counsel has recently been informed that Judge McCarthy-Neyman had an ex parte and undisclosed conversation with Assistant Chief Probation Officer Jeff January on September 10th, 2025. What's that about? This conversation occurred the day before the court revoked Miss Fitzsimmons' bail and returned her to custody, cut off defense counsel, invited objections from the Commonwealth, walked off the bench when counsel was addressing the court, vilified the court probation officer January in open court. She went after her own probation officer, and she was visibly shaking and angry. And we couldn't figure out, why was she angry? See, I do like that they're talking about that she's a taxpayer, but that would make somebody angry. I still can't figure out why this judge, I'll call her a lady, why this judge was so angry. And she was visibly shaking and angry. All of this is factual. This is what we all saw. Counsel was informed by a court probation officer January and his attorney that Judge McCarthy-Neyman came to his office unannounced the day prior to the hearing. She sought to investigate the status of Miss Fitzsimmons. Is she a investigator now? What the hell's going on here? She sought to investigate like she's working for the DA's office or some shit. Does she work for North Andover Police? She's investigating. The judge is investigating. She sought to investigate the status of Miss Fitzsimmons' compliance with probation terms and was informed by a court probation officer, January, that there was no violation. January recalls that he discussed the fact that he had emailed communications with undersigned counsel, which appeared to upset Judge McCarthy-Neyman. She got upset. How dare you talk to the probation officer? What? But that is insane. Shouldn't a court probation officer be in contact with the person that's in probation and their defense if they have any questions about it? What is wrong with that? Why would she get mad about that? When January mentioned that his emails favorable to the defense were likely attached to the motion filed for relief, McCarthy-Neyman abruptly left January's office. She got very mad. Look at that. She got very mad. There was no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel, off the record and without subsequent disclosure to the defense. I need another drink of water. This is unbelievable. She's holding secret meetings with probation, not disclosing it, and she's trying to investigate Kelsey. Is she a judge or is she a detective? This is unbelievable. Unbelievable. What the hell is going on here in North Andover? Is something wrong with the drinking water over there? Now I gotta say, I got mad respect for North Andover because of their wrestling team. So I don't hate North Andover. I got so many great wrestlers. One of my the coach I had when I was a senior in high school, he was our assistant coach on the team. Probably the greatest high school wrestler ever. Guy named Von Hain from North Andover. Probably the greatest North Andover wrestler ever. And they've had so many great wrestlers over there. They broke national records over there with how many dual meet wins they had in a row. The streak that they had. All right, enough about the wrestling. These ex parte communications concerned matters bearing directly on the defendant's liberty, which was at stake, unbeknownst to the defendant. See, they didn't know that this was going to happen. This judge was already plotting. This judge was plotting, and the defense had no idea. That's why they got ambushed. Such conduct directly violates Rule 2.9, prohibiting ex parte communications, where a judge receives information outside the adversarial process and then presides over related proceedings. The appearance of impartial adjudication is irretrievably lost. Wow. Personal embroilment with the probation and defense counsel. Wow, you reading this? Well, they just got informed recently that September 11th, 2025 hearing on the emergency motion for relief, McCarthy-Neyman filed a complaint against the probation officer. Wow. So she does shady shit and then she files a complaint against the probation. Like I said, can you imagine working with her? I said that when this happened for the poor probation officer. Can you imagine working with this judge? If she acts like this in public with the cameras on, how does she act in private? This is how she acts. She filed a complaint against this guy for just doing his job. Wow. What is wrong with her? Is she sundowning? Maybe she needs to be off the court. Like maybe they need to look into her, like her mental health. Something's not right. Upon information from January's, now January had to get an attorney. The probation officer had to get an attorney because of this judge, her complaint. The complaint filed by McCarthy-Neyman included accusations of defense counsel colluding. They're colluding with the probation. They're colluding to keep Kelsey out of jail. Oh my God. Are you shitting me? I'm sorry I'm screaming, but Jesus Christ, I can't even believe what I'm fucking reading right now. Are you kidding me? This poor probation officer, he's probably getting like, what's he getting paid? 50 to 100 G's a year, and he's got this judge on his ass for doing his job? And now he's got to get a defense. Now he's got to get an attorney because she filed a complaint against her. Holy HR hell. This lady needs to go. Not only does she need to be recused from this case, she needs to be recused off. She needs to find a new job. They need to retire her. This is outrageous. Yeah, this is my opinion. Yeah, this is my opinion. Exactly. It is my opinion. I would not want to ever work with her. Unbelievable. She filed a complaint against the guy for doing his job. We saw him in court. He was fair and balanced, a nice guy. Exactly what you want in a probation officer. This is unbelievable. What is up with this judge? Not only does she have it out for Bradel, she has it out for the probation officer. Not only does she have it out for Kelsey, she has it out for the probation officer. At a hearing on the January probation matter, undersigned counsel would attack this court's position and credibility and assert that the court's complaint is false, baseless, and merely dissatisfaction with an undesired viewpoint from probation. In fact, counsel would also assert that January at all times acted fairly, truthfully, and professionally, which he did. And that's the thing. That's my opinion, but it's also backed up against by the counsel, who said that he did act fairly, truthfully, and professionally. Mr. January did everything that he could to accommodate Ms. Fitzsimmons' disability. That's what you're supposed to do. Unlike the court itself, it deserves praise and the full support of the probation department rather than an assault on his reputation. Yeah, do we need to do a standout for Mr. January? Maybe we need to stand out. Free Mr. January. Because this guy got a bum rap from this judge. She filed a complaint. What a dirty, rotten thing to do. Further, the court's complaint is proof that the court's foray into ex parte investigation before the hearing simply didn't produce the desired information and resulted in the court vilifying probation officer January the next day at the September 11th hearing, without any cause whatsoever. In addition, and perhaps most compelling for recusal, the fact that the court did not disclose the complaint to counsel for Ms. Fitzsimmons is strong evidence of the judge's lack of impartiality. The judge's bias and lack of impartiality. Can you believe that? So this judge files a complaint against the probation officer. Doesn't even let Fitzsimmons' defense know about it. Wow. Yeah, can we file against this judge? Can we file some complaints? This is unbelievable. I feel horrible for this poor probation officer who was doing his job. It's unbelievable. She filed a complaint against him. A judge who has entered the fray, particularly by leveling accusations against counsel of record and court employees. That's the real thing that drives me nuts right now. These poor guys, they're just doing their job. They're not highly paid. They're not appointed like a judge. They're not political appointees like this friggin' hack judge. This poor court employee. I think she needs to recuse herself. The court must recuse. I agree 100%. This judge needs to recuse herself. Outstanding questions created by the court's conduct. Based on all the foregoing, many questions have been raised that create a scenario where the judge's impartiality must reasonably be questioned. Answers require an evidentiary hearing to obtain facts that would likely show that her impartiality is compromised. The questions are including, but not limited to, the following. Is the judge related to Patrick McCarthy-Neyman? And does she know him? Does she personally know him? That's what I want to know. Does she know Chief Gray? Is she friends with Chief Gray? That's the one I think she might be friends with Chief Gray, North Andover Police Chief. Why is the judge covering every hearing on this case through the trial? Is there a written order to the effect? Why did she repeatedly leave a civil session to cover this matter? What specifically in her complaint to the probation department concerning probation officer January's actions? Yeah, what is in that? I want to see that complaint. We need to see that complaint. The public has a right to know. Can we file? Somebody needs to do a FOIA. Let's do a FOIA. Maybe we need to talk to LTL on this one. How do we get her complaint? I want to know who she complained to. Then we can, what office? I guess the probation department. So let's find out. Let's hit up the Essex Superior Court Probation Department and request a FOIA on the complaint itself. Why did the judge disclose the existence of a probation complaint involving the defense on Miss Fitzsimmons' own criminal matter? Why did the court have an ex parte meeting with January in his office? Why did the judge disclose the meeting and comply with the Code of Judicial Conduct? Did the judge use any inside info obtained against Miss Fitzsimmons? See, I don't even know what the rules are for judges in court. I'm not familiar with the judicial conduct, the Code of Judicial Conduct. But just being an average person, I can see a conflict of interest. This is a big time conflict of interest. And she should have never had an ex parte meeting with this guy and then not disclosed it to anybody. Why is defense counsel's advocacy perceived by the court as manipulation or collusion? Why is the court using such descriptors which are indicative of bias? This is unbelievable. This is what they're requesting. Wherefore the defendant respectfully requests that the court grant an evidentiary hearing, order the recusal of Judge McCarthy-Neyman, reassign this matter to a different judge by means of reassignment not involving Judge McCarthy-Neyman. Yeah, don't let her pick who it is, and grant such other relief as justice requires. Look at this. Respectfully submitted by Kelsey Fitzsimmons to defendants and her attorneys, Timothy J. Bradle and Martha Coakley, who is the former Attorney General of Massachusetts. Wow, this is amazing. This is wild, folks. When was this filed? Is there a date on this? Did we see the date at the bottom? What day was this filed? Was this today or was this earlier in the week? I missed the date. Hold on. There's also some February 8th. So this was what? Today's the 9th, right? Am I right on the right day? This was filed yesterday. Wow. Hot off the presses, folks. And we got more. We got more to cover here. Let's pull this off and let's look at the next one. Yeah, they found out from January and his lawyer, it looks like, right? I want to know who Jeff January's lawyer is. Maybe we can get him on the show. Wow, is he a union guy? Is he a union lawyer? I wonder. Yeah, she was intimidating that probation officer, and then she filed a complaint against him. He should file a complaint against her. I hope he sues the shit out of her. Jeff January, probation officer, sue that judge. That's what I'd be. You better consider suing her. She's affecting your livelihood and your credibility. He did nothing wrong. This is unbelievable. This is unreal. Yes, please hit the like button. If you aren't following, subscribing, please subscribe. And make sure you hit your notifications bell. Some people are saying they're not getting the notifications when we go live. Make sure you hit all notifications. You want all notifications. You want to make sure you are alerted anytime we're live. Yeah, I know. Why did she think she'll get away with this? See, now I'm aggravated I didn't go to court today. Even though I get to cover this. This is great covering this right now on my break. Before I go, I got to go walk a dog. I'm supposed to be there at noon, so I'm going to have to leave soon. But Jesus, I wonder what if Tim and Martha said anything outside of court today. Wow, this is unbelievable. This is just shocking. This is wild. And there's actually some let's look at this one more thing here because there's a exhibits. We haven't shown the exhibits yet. Let's bring up the exhibits. What do we have for exhibits? We got 12 pages of exhibits. Wow. Let's take a look at these. I may be late for my next dog walk. It's all right. They'll be fine. Let's bring this. I got to bring up these exhibits. I got the right one up? No, I went back to the wrong one. So hold on. Sorry. Share this one instead. Hold on. This is unbelievable. Why won't it come up? God damn it. Hmm. Oh, it's there. All right. Geez, I have a feeling Mass Lawyers Weekly is going to be covering this one. This is wild. I'm gonna have to hit up some of my lawyer friends to come on here and talk about this now. Wow, this is just so now they look they've submitted evidence of where she was supposed to be. There it is. She was supposed to be in Salem Civil A during this period of time, August 4th to August 29th. So this is the first part of the exhibit showing. Where is she? There she is, right there. So she was supposed to be at Salem Civil Court, and all of a sudden she ends up on a criminal matter. What's up with that? So that's the first exhibit showing all the schedules. I wonder how they got the schedules. That's interesting. Exhibit number 2. Ah, look at. So there you go. Dreschler, Bloomer, Dunnigan, Essex County. Actually, that's county. I don't know if that's Superior. Let's see if they show Superior. It's interesting that they've highlighted different names like Beverly Canoni. So I think they might have got this through a reporter, maybe. That's what it looks like. It looks like it comes from Mass Lawyers Weekly. So the exhibits so far are the schedules, the court schedules. Exhibit number 3. Do we have this on the screen? Let me make sure it's all on the screen, right? Yes, it is. Good. You guys hearing me? It's not, the mic's not cutting out again. This is unreal. This is so wild. I was not expecting this today. Oh, so now they're showing what happened when there was a conflict with the town of Ipswich in the same courtroom with a different judge, Kristen Buxton, Associate Justice of the Superior Court. She did the right thing. Kristen Buxton, good job. September 29, 2023, she recused herself. When something was in front of her with the town of Ipswich, where she's a taxpayer, she recused herself. So that's it. Those are the exhibits. That's it. 3 exhibits. Did you see all of them? I want to make sure you saw all that. Yeah, you did. I got it on the screen, right? That was that previous case that they talked about. Copythorne versus Stephen Crane and his capacity as town manager of Ipswich. And this judge did the right thing. She didn't even let it go to appeal or go to SJC. She just said, after review and consideration, this associate justice shall take no action on the motion at this time, and I recuse myself from this action. So she decided to do it. That's what this judge should just copy and paste this and put her name on there today. That's what she should be doing. If this Judge McCarthy-Neyman doesn't do this today, they should take her offer. They should suspend her license, like literally. If she doesn't copy and paste this today and put it in the court record, we should be asking about her competency as a judge. Yeah, like that's the thing I'm wondering about. Super Squirrel, exactly. Is she sundowning? Is she somebody that's just lost it? Because that's what it seems like. I know I lived with somebody who had some dementia, not Alzheimer's, but a mild dementia. And this is what I saw from that judge seems similar. You wonder, has she lost it? This is unbelievable. I think we need to do a standout protest as judge, but also supporting Jeff January. We need signs. We support probation officer Jeff January. We love Jeff January. Jeff January is a great probation officer. He's exactly what we want. And exactly. Otherwise, if it's not some kind of dementia, sundowning situation, then I question why is she taking it so personal? Like, I think there is a conflict of interest as a taxpayer in North Andover, but I don't think that would make you so angry. Do you know what I'm saying? Like, she's so angry. She was so personally invested. Ruthie, great point. It is personal. What is so personal about it? Does she know Chief Ray? Does she know Officer Noonan? What's so personal on this? This is unbelievable. That she actually filed the complaint against this poor probation officer. It's unreal. Yeah, does she have a connection with Justin's family? That's another one. Who was she connected? It seems like she's connected to somebody, the way she's acting. What I want to do then to close the show today is we're just going to go back to September, when she had her nutty. We need to find. If anyone has the link. Actually, you probably can't post it unless you're a mod. I can find it. I want to go back to. Let's see if I can search it real quick. See, I wasn't expecting this. I'm on the fly, folks. I'm not prepared. Let's go back to Kelsey Fitzsimmons. We'll go back. There's been a lot of Kelsey. Here's the court audio. I found it. Yeah, we're gonna close the show with this. This is what it's about. No, wait. Uh-oh. Oh, hold on. Hold on one second. We're going back to when it all happened. One thing I'm gonna do first. Hold on one moment. And I should be careful myself because this is my district. That's what I always worry about when I cover stuff that's so close and personal. But on this one, it's like, you know what? I can't help to get upset with this judge. This is unbelievable. Hold on. It's not shared, is it? Hold on one moment. You guys can't hear that, right? Let me just check in the chat. You can't hear what I just played, right? I'm doing too many things at once. Here we go.
Number 2025-311 before the court in the defendant's motion. If the parties would please identify themselves for the record.
Good afternoon, James Gubachowski on behalf of the Commonwealth.
Good afternoon. Good afternoon, Attorney Moriarty for the Commonwealth. Good afternoon. Good afternoon, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons. Good afternoon.
Hello, Your Honor. Timothy Brado for Kelsey Fitzsimmons. She's present in the courtroom today for the record.
Good afternoon, Mr. Good afternoon, everybody in the courtroom.
Thank you.
So I received the defendant's emergency motion for immediate release from the Scram order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them, but she has about 4 hours of pain and dizziness afterwards. And I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, we're not trying to get any sort of advantage over anything. We just want her to not be in pain for hours after these tests, and B, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, I think that says it all. That's someone that has no bias or interest, and, probation enforces court orders, and that's that. And he is telling the court this is a problem. And, this is something that should be addressed. And
okay.
So I see this as a simple adjustment of terms.
I don't see it that way, just so you understand where I'm coming from. I don't see it that way.
Okay, can I?
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just the means of determining that's the adjustment. That's what I mean when I say this is an adjustment that.
Well, a scram is what was ordered.
No, this is the court order, the court hearing. where she had already met with the probation officer secretly. This judge, this is what's cited in this. It's cited. This is what's cited. This is unbelievable. It's even worse listening back to it today, knowing what we know now. And then she filed a complaint against the probation officer. Unreal. What a terrible person to work with.
Now, was she unable, when you said that there was a knock on the door, explain that to me. What
No,
happened?
Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door
Okay.
because of these tests. It's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay.
And that, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just, that's something that I just want to ask the court to adjust somehow.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email, it's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay. So you have a burden, it's your motion, what do you want to do?
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happens. I think that's, the more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother, you have an affidavit from Ms. Fitzsimmons, and the other day we were here, I submitted I believe I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I just would just argue that it's somewhat self-evident as well. Thank you. That it's somewhat self-evident as well, and that, she's having great difficulty here. It's been observed by probation. It's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant. And
So I want to hear about the one she had difficulty with. When was that?
Take a second on this.
Yes, people are asking about the video. There was no video back then. Only an audio recording was made. I was actually live in the courtroom, so I did view this, and it was just as bad as you think. Like, I've been to every court hearing except for today. Today was the first court hearing, basically, I haven't been to. But there was no video at this point. It was just audio. So we're playing the audio today. But it was terrible.
Well, so that's what I was saying, Judge. I don't want to conflate passing with not having difficulty. She has difficulty with every single test. And so she passes them in great pain. So she's had difficulty in every single one, equated, it's in the affidavit. So she has difficulty on every single one. So that's a different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes,
And she was unable to perform it?
correct.
Okay, was she unable to perform it?
No.
What happened?
No. So this, since she's been released,
Yes, swearing off.
Would
The
you raise your right hand,
probation
please?
officer.
Do you solemnly swear you will make true answers to such questions that may be put to you by the court or upon its direction, so help you
I
God?
do. Your Honor, if I could just pass this up. This is
Sure.
information pertaining to all of our students.
And is that being submitted, Attorney Bradle, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Your Honor.
Okay,
It
so we'll-
just says that she passed the test, which is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes. or not.
Okay, so there's one, Officer January that says incomplete at 9:10:25 at 3:09 PM. Is that right?
That's correct.
So what does that mean?
Yes. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially, she answers the alert and attempts to take the test, but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries, and then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 PM.
Okay, what I have in front of me is an incomplete test at 9:10:25 at 3:09 PM.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9:10:25 at 9:30 AM.
okay, so you're looking, I'm referring to this the second document, it's multiple pages.
Mhm.
I think if you just go up instead of the one above it, the
Okay,
incomplete is the. nine-
so it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
Again, at 3 o'clock.
but she
The test is initially incomplete.
at 3:09, and then it's complete at 4:21.
Yeah, 4:21.
So there were two times that she had an incomplete test. Is that
Yes,
correct?
Incomplete, and
And what's the procedure of the probation department when somebody who has a condition of release to have a scram and to pass the scram test in a very serious case if they're incomplete? And I have two incomplete tests and I was not made aware of either one of them.
so my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, actually doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, like genuine
Okay.
pain. So I know,
Any objection to any of the terms used by the
No.
probation officer? Okay.
so we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and she, with her
What do you,
obstacles.
I'm getting confused. What do you mean compliant?
That's-
As far as when
that's-
she was initially,
That's compliant with scram testing. She was ordered,
when she initially was, started to be monitored by Scram and you went through the preparations, is
yeah,
that right?
that's correct.
Okay. So when something is incomplete, you typically bring it to the attention of the
No.
court.
No, that's not what we do. So if something is incomplete, as in this case, at 3, on September 9th, at 3:09, we have an incomplete test, which is a scheduled test.
Mhm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance. If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
Well, that's
to
your,
me,
that's your position, that's non-compliant.
Well-
It's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying is those
there would
situations
never,
you
ever-
described is what you deem as appropriate to bring before the court.
it would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation or from our end.
Right.
Because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and we don't deem that non-compliance. That we never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so, the schedule for her to be tested is something that we discussed. Wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows
I
when she's going to be
discussed-
tested?
With Ms. Fitzsimmons, I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens, excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule,
With
as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I could clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing, we always default to creating a testing schedule,
Okay.
and up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the test is coming. And the test to be done randomly. And at that point in time, we would take her off a schedule. And then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case and it's done on every case.
Okay. Attorney Bradle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard Your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No,
Bradle?
my objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, it says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that the scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
Well,
Sponte?
if the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's
Thank
for the motion to vacate the scram device. So do you have anything else to submit, Attorney Bradle?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is. In light of the court releasing the defendant, that testing be done.
Okay. Attorney Bradle, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate that the material represented in the.
The court is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it
Okay.
under the terms that are
So-
laid out in the
So
affidavit
you're saying she can do it on her own terms?
with significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all, so I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for alcohol compliant, lack of alcohol, that's completely fine with the defense, but just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that,
Oh, okay.
but
It is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scrim as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that
Okay.
can be put in there as well. But Judge, I think that, that there's probably other alternatives that she could do that I believe are out there but I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes and I'll be right back.
Court, all rise. Goes back to testimony.
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws, Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scrim monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scrim installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scrim, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scrim. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a
Your Honor,
written
may I
order will follow.
address the court?
That's the court's order. Thank you.
All
Your
right.
Honor, I object. I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.
What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to be talking about Kelly Devers' resignation. That happened at a very interesting time. It was reported even further back, closer to the trial. And then there was some
Wow. Hold on. Hold on a moment. All right, that was wild. The reason I brought that up today for people who are late is the hearing was canceled today, but there's a new motion by the defense to recuse this judge based on that hearing, but also based on the fact that she filed a complaint against this probation officer, did disclose it to the defense. She also had a ex parte meeting with this probation officer even before this hearing that she did not disclose to the defense. So they're trying to get this judge removed. I think it's actually a very strong motion. I'd be really surprised if the judge herself doesn't just recuse herself. If she doesn't, it's another head scratcher. Yeah, we got bounced to lawyer, for a second on my old video. It's funny. Sorry about that. But that was unbelievable. I'm going to head out now. I'll be watching the Savannah Guthrie, see if there's any updates on that today. We might be live again later today. Check back. Make sure you subscribe and like us, follow us, whether you're watching us on Facebook or Twitter or YouTube or anywhere else. Make sure you subscribe and like and follow. I got to go walk some dogs in the cold. Yes, that's right, Natalie. I can't believe this no motion. It's unbelievable. For people that don't know, the hearing did get canceled today, but we just went through the new motion. And it is, I just did update it to the Young Jerks Facebook group if you want to read the motion yourself. It's right there, the PDF. I also pinned it in the chat, in the YouTube chat, so you can just download it right there. I'll see you later today, probably, hopefully. Thank you so much, Jerks. Thank you to our moderators. Thank you, everybody here. Mary Malarkey's here. Mia's here. Victory. Natalie. I love you all. Thank you so much to the ladies in the chat. Our mod team. Yeah, I know. Did Officer Noonan even ask for protection? I don't think he's afraid. Why is this judge so worried about it? We'll see what happens. We'll see what happens very soon. All right, folks, have a great day. I will see you soon. And again, I will be covering this trial. It's expected to happen in March. I will be there. We will be there. We'll be covering it. We'll be streaming it. Looking forward to this trial. And if you're just getting here, watch from the beginning, because we go through this new motion, and it's explosive. You need to check it out. All right, everyone. I'll see you soon. Have a great day. Peace out.